So welcome back, Bex and Leah, episode 5. Welcome back, landlords, letting agents, colleagues, friends, family. I know, episode 5 already. We're going to lighten the mood a bit today because I know we've had some scary eviction stories and we just want to gamify this a bit and answer some of the questions that landlords and agents have posed to us after the first few episodes. So about the process, the eviction process and so on. So we're going to gamify it. We're going to play a true or false game.
Yeah, we've even got our cards
So
ready.
cards at the ready. So I'm going to read a scenario out and you guys hopefully are going to agree on whether
Hopefully,
it's
no
true or
pressure.
false.
I know.
So the first one is a tenancy deposit question. So true or false? I'm a landlord. If a landlord and a tenant have a mutual written agreement that the tenancy deposit does not need to be registered with a government approved scheme and can be held in the landlord's personal bank account, is this sufficient when there is mutual consent of all parties?
False.
Phew, both agreed.
That is something that is quite a common question.
Yeah, I can
Believe it
imagine
or
that.
not. Yeah, landlords seem to think if it's, both parties are in agreement, then they don't have to go through the deposit scheme and
Yeah.
it can just be held in account. Sometimes they say it's in a separate account that, I don't really access. I'm not going to spend it. It's just going to be there. No.
Yeah.
You need to go with either My Deposits, DPS or TDS. Make sure it's registered within the 30 days.
Even if they're family or friends,
Yeah,
you get that all the time.
regardless.
Even more so with the family, probably.
Yeah,
Even
it's,
more so.
it's my
Yeah.
best friend of 10 years. It doesn't matter.
Yeah, that's the best way to fall out, friends, I would imagine.
Yeah.
Are there different types of deposit schemes? So insured.
Yeah, so you've
Yeah.
got the custodial and the insured,
Yeah.
and it's completely up to the landlord what option they go with. And again, for the free schemes, all very, very similar, to be honest.
But if a landlord is in doubt, then just pick the phone up to one of your team and you'll advise on the best way forward.
Yeah.
Amazing. Great. That's a good start. You both agreed
Yeah.
on the answer for that one.
Thankfully.
I knew you would anyway. No doubts. So scenario 2, and this scenario is a ground 1 for possession question. So is this scenario true or false? A landlord can rely on Section 8, ground 1 for possession. So the landlord intends to live in the property as their main residence, even if they did not inform the tenant in writing at the start of the tenancy, as long as they have evidence that the property was their main residence prior to the commencement of the tenancy.
False.
False. I thought you were keeping your options open there, Lee. With your true.
Just false.
Just in case.
Just in case I change my mind.
And false because...
No, to rely on ground 1, you have to notify the tenant with written notice on or before the commencement of the tenancy. If you've not got that, you can't use that ground,
No flexibility
unfortunately.
at all.
None.
No. Okay. That's good. Good to know. So, scenario 3, true or false. How to rent guide question. And you must get these all the time because I think there's a lot of questions around the how to rent guide.
Yeah, I think because there was 2 released around the same time, March and October 23, it caused a lot of confusion for landlords. So very common questions. Yeah.
And I think that's another reason why landlords and agents do need to make sure they keep in touch with us, because if we know of any changes to key documents like that, then we'll always keep our agents advised, or Romario will keep our agents advised. So the how to rent guide question, true or false? It's considered best practice to serve a tenant with the most recent version of the how to rent guide, which will be October 2023, even if their tenancy is long-standing and began way before the version was published. Is this true or false?
True.
Because?
Yeah, so it's actually not a legal requirement to serve a copy of the most recent how to rent guide if it's been a long-standing tenancy, but it is best practice. And based on our experience in the eviction side, at court offer Section 21 notices, judges actually look to confirm that the October 23 how to rent guide was served before the Section 21. So it is a bit of a grey area, like Leah said, even though it's not legally there and we've not got that word in, just serve it, because it's not worth taking the risk if you do have to make a claim in the future.
I think 2 things with judges is that, one, they want to see landlords and agents acting, and complying with best practice. So, and almost you would think best to give the tenant too much information than not enough. So if you're in doubt, just give the
serve
anything, anything that comes out, just serve it.
Just serve it. And the other message, to keep a copy of what you're serving as well.
Yeah.
And the date that you've served it to the tenant.
Yeah, the date and how.
Yeah.
So, for example, not to go off, but in your tenancy agreement, there will be a clause for notices. So that would say, for example, notices need to be served via first-class post. So if you serve that recorded delivery as well as a deregulation document, then you've got yourself a problem. So always serve exactly how it states in your agreement.
So if I'm a landlord and I phone you up, Bex and Liam, and say, I've had a tenant in for 5 years and I want you to do a landlord compliance audit, and then you see that I haven't served the October 2023, can I just issue that today?
Yeah, so we would take care of that for you, basically. Yeah. So anything that should have been served that hasn't, we will serve that to your tenant on your behalf.
Okay. So then when it gets to court, if I want to gain possession, then the judge is going to say, well, you've acted well and, you're complying with best practice. So the judge will look favourably on it. I think we've learned, haven't we, that whatever hurdles you can take down when it goes to court, the better, really.
Yeah, exactly.
Yeah, exactly.
It's all about building that case up to be as strong as possible.
Yeah, absolutely. Okie dokie. So scenario 4, and this is a section 21 notice validity question, true or false. So a section 21 notice is valid for 6 months from the date of service, meaning that even after the initial 2-month notice period has passed, a landlord can grant the tenant additional time before applying to the court for possession. That's a very long question.
True.
True because, Leah?
So a section 21 is valid for 6 months from the date it's served. So as long as you apply to court within those 6 months, it's completely fine.
Amazing.
We had a case this morning,
just before this morning.
We started recording, where the landlord approached us for a court application. They'd served their own section 21 and they'd served it, I believe, on the 18th of February. So it expired yesterday. The 6 months was up, and so I've contacted the landlord to give them the bad news, and they thought that it was actually 6 months from the expiry.
Yeah.
Right.
That is common.
And he said, I've been really busy. I've been wanting to get this case over. I've just not had the opportunity. And now they are going to have to reserve another 2 months notice before we can go to court.
So are we going to do that for them and make sure we've got a diary note? So
exactly, yeah. So we would always contact them as soon as a notice expires, a week before.
So the landlord, just to confirm, has up to 6 months from the date of service to issue the possession claim?
Yeah,
exactly.
Yeah.
Not an hour too late.
No.
And
I would say to landlords, it's absolutely fine to give the tenant extra time. So after your 2 months notice, if sometimes these landlords have a good relationship with the tenant, if they're looking for private accommodation and they are genuine, then you can give them an extra month or an extra couple of weeks
with mutual agreement.
Yeah. Don't leave it longer, don't leave it till month 5, because we know what courts are like at the moment. If you've got to send the application manually, that can cause problems. So yeah, you can give them the additional time, but don't leave it too late.
And can it be done any time within the 6 months?
So you've got to wait for the 2 months notice to expire.
Months,
so essentially
between
4
2
months.
and 6.
Yeah.
Okay. That's your window, really. That 4 months window. Oh, great. That's really helpful, that. So scenario number 5, around evictions and the process for evictions, true or false. So once a landlord has obtained a possession order from the court, which might take some time in London, as we know, they are legally permitted to enter the property and change the locks if the tenant fails to vacate. I think even I know the answer to this one.
False.
Big no. Definite big no.
But you would be very
tempted.
Yeah, you'd be very surprised how many people think they can just go and change the locks.
Really?
A lot of landlords seem to think, well, I've been to court now and I've got the order, I've got the official paperwork. It's my property again. Why can't I take possession? It is so common for landlords. I would say we have that conversation daily.
Yeah. Really?
Yeah.
That often?
Yeah.
Gosh. I suppose as well, if you're a landlord that's waited 18 months in London, are you keen to get the locks changed and get things moving, aren't you?
Exactly. And then you've got us, the bearer of bad news, telling them it could be another 20 plus weeks just for the bailiff appointment. But what I would say to any landlords that are, tempted to do that, it's not worth the risk. You can be fined for an unlawful eviction. If the tenant was to return, if the they went out and you changed the locks and they did return, not only an unlawful eviction, but also you'd have to give the tenant the keys back and you probably have to start the process all over again.
Right,
So
okay.
it's not worth that risk at all.
Right from the beginning, you
Right from the beginning.
No, that's definitely on risk. So just to confirm then, so a possession order only gives the landlord the right to apply for the warrant of possession.
Exactly.
And what's the final step then for the landlord?
So once that possession order comes through, it'll normally give them 14 days from the order of possession to vacate, but they can allow up to 42. If the tenant is, not going to move, they're still there, you have to apply for that county court bailiff, or if you're lucky enough, apply for the high court bailiff to come and actually remove them from the property. You can't go change the locks.
So just remind me then, the high court bailiff, when would that option become available?
So that would be at the hearing. So if there's rent arrears, or some now we are seeing an increase because of significant time waiting, that courts are awarding high court. So it'll be on your possession order. It'll say something like transfer to high court enforcement, and then from there you can get a faster and private bailiff.
Okay, amazing. Great. So we've done our true and false a little game. So that was great. And you agreed on all the answers, which I knew you would anyway. But that was
I'm glad we
luckily.
did.
But that was great. So I've now got a few scenarios that landlords have sent in to us following the episodes that have been released. So just want to throw these scenarios out, and then you guys can talk me through, how you would handle them, what next steps are, and so on. So the first scenario is a landlord has called and said they've just realised they forgot to protect their tenant's deposit. The tenancy started 6 months ago. They've now served a Section 21 notice to end the tenancy. They're asking if their notice is still valid, even though they've now put the deposit retrospectively into a scheme. Leah, you look very sad at this scenario. This isn't looking hopeful.
Common
Leah's
one.
about to be the bearer of bad news.
Yeah, so
You're not even going to say case by case basis.
No, not case by case. Unfortunately, that Section 21 would be invalid. And the first thing that you need to do is return that deposit to the tenant. Unless it's been registered within 30 days, you do lose the right to have that deposit. So return it to the tenant either through the scheme, bank transfer, cash as a very last resort with photo evidence. And then at that point, if the rest of your documentation is in order, you can then serve a Section 21 and give them an additional 2 months' notice.
Gosh. So when that gets to court, is the judge going to look at that not very favourably? Will that not affect them gaining possession?
Once the deposit's returned, as long as the landlord's got the evidence, then that shouldn't affect proceedings.
Affect the case.
No.
Good. Well, not good for the landlord. But it's just going to delay things. So, just another lesson really, and just look at your checklist. Make sure you get your checklist off us and make sure that you're ticking all the boxes on there. So scenario number 2. So we've got a landlord who's just found out that their tenant has a dog, large dog, and the tenancy agreement states no pets. So the landlord is really furious because they're worried about damage to the property. They want to know if they can serve a Section 8 immediately and what the grounds for eviction may be.
Yeah. So whether it's a large or small dog, the advice stands. So in that situation, this would fall under Section 8, Grounds 12, breach of contract, which is a discretionary ground. Now, in line with all the changes that will happen with the Renters' Rights Bill, obviously with regards to pets, what we would say is, no, it's not ideal that the tenant's breached the contract, they've got a pet. But realistically, if you go to court on a Section 8 notice based on the tenant having a dog, it's a weak case. And that's just to be completely transparent. We wouldn't recommend it. What we could do is send letters, to the tenant, but ultimately, very unlikely you'd gain possession just on that one breach.
Right, okay.
You would need significant evidence that there's been, that pet has caused significant damage or, been dangerous within the area or whatever it may be.
So if the police have been involved with the pet, for example.
Exactly. It's with discretionary grounds, it's all about the evidence that you present. So if you have got, police involvement, crime reference numbers, complaints from neighbours, you've done an inspection and you can see clear damage from a pet, then we can build up a case. But if it's just the fact that they've got the dog in the property, that is very unlikely to get the landlord possession.
It's just not strong enough.
No.
One thing I would say, though, that if a landlord is in that scenario, to talk to us about pet insurance, because we can put their minds at rest with covering them if there is a pet there. Scenario number 3. So a landlord has a tenant who is a month behind on their rent. They've served a Section 8 notice, but now the tenant has paid half of the arrears. We see this all the time.
Mm-hmm.
The landlord wants to know if the notice is still valid or if they have to start all over again.
This is one to unpack quite a bit.
Unfortunately, Section 8 was invalid with the fact there was only 1 month's arrears outstanding. So for a Section 8, if you'd listened to the earlier podcasts, you would know you have 2 months rent arrears and then you can serve the Section 8. So if there was 1 month and then they've, cleared half of them, Section 8 isn't the option for you at that point. We would recommend our mediation process to try and open up that dialogue and try and engage with the tenant to see if there is a reason why rent's not being paid and to see if we can sort of build a bridge to actually continue the rent payments.
Yeah. I think with the Section 8 note as well, it depends really what grounds that they've pleaded. So not to get too technical, but typically with a rent arrears case where there's rent arrears over 2 months outstanding, in order for us to plead the mandatory grounds, we'd rely on 8, 10 and 11. So in this case, if the arrears is less than 2 months, they may have pleaded grounds 10 and 11. So that's a discretionary notice. So similar to one of the previous questions, if the tenant's cleared the arrears but had previous arrears, then if you was to go to court, you'd be relying on discretionary grounds. So it's a weak case again. And due to the fees that you would pay in the timescales, we wouldn't advise it. So exactly as Leah said, we would start the mediation process.
Yeah, I mean, this to me jumps out as being a really good example of the benefits of mediation. This tenant looks like he is trying to actually make inroads into his arrears. So actually just to have that mediation service and to get some formal agreement in place maybe, then, that's probably the best interest of the landlord and the tenant, I would think, in this case.
Exactly. And especially with discretionary grounds, the judge will look at the missed payments and late payments, but they'll also take into consideration the tenant is trying to rectify those breaches and possession is a last resort.
Yeah.
And I think you had a case similar recently, didn't you, where very similar to this and mediation was actually successful?
Yeah, mediation was successful. The tenant was completely honest and said he was switching between jobs. He ended up building his relationship back up with the landlord. And as far as I'm aware now, everything is completely fine and the rent arrears are paid.
I think our mediation service, I think it's just great at opening lines of communication, because understandably the landlord gets a bit frustrated and probably really stressed and worried about the fact he's not getting his rent. The tenant might be going through life situations that's impacted, and he's also going through a stressful situation as well. So I think for us to be that objective third party to be able to open those lines of communication, I think we've seen some great success stories from that. So always definitely the best thing to think about. So scenario number 4, a landlord has a tenant who hasn't paid rent for 2 months. They haven't seen them at the property for weeks. The tenant isn't answering their phones or emails. The landlord is convinced that the tenant has abandoned the property and wants to know if they can change the locks and relet it. I think I can guess what you're going to say here.
Abandonment is such a grey area.
Yeah, it's one of those things where a landlord thinks, brilliant, they've gone. They're not there. They're peeping through the windows.
I was going to say they've looked through the windows.
Yeah, they're speaking to the neighbours. The neighbours haven't seen them in weeks.
Yeah, but there's been no formal surrender. So you can go down the abandonment route. You can place that notice on the door, give them the 14 days. If you have their email, send them a copy. But if they come back, you've got to let them in. And if they come back and, you've taken possession, you could unfortunately be penalised for having that unlawful eviction. So we would always say, wouldn't we, just start the legal process regardless.
So could I do both at the same time? Could I issue the abandonment notice and start the notice at the same time?
Yeah, that is quite a common process. Obviously, landlords serve the abandonment notice with the hope that they'll receive something from the tenant to say that they've left. And what I would say is a common question. And what is a formal surrender? So something in writing from the tenant confirming they have vacated the property on a permanent basis and all sets of keys. Yeah. If it's husband and wife and you've received one set of keys and one email from the wife, then that is not a formal deed of surrender because the husband could still be there with his set of keys. So we need all sets of keys back.
So all parties to the AST, the tenancy agreement, would have to
return
formally
the keys
surrender.
And formally surrender, yeah.
Okay, that's really helpful. Thank you for that. And the last scenario, a landlord needs to carry out the gas safety, which we know needs to be done annually. They've given the tenant over 24 hours written notice, but the tenant is refusing to let the gas engineer in, saying it's inconvenient. The landlord is worried about not being compliant with the law and wants to know if they can force entry or if they can serve notice for breach of the agreement.
So what we would recommend first is, before the landlord has obviously come to us, they typically have tried numerous times to gain access. One thing that we would say is serve an access request letter first. Sometimes having that third party, again, builds that communication. They may allow access. If they don't at that point, we agree Section 8, breach of tenancy, or you could go down the injunction route, but that is timely, costly. So Section 8, breach of tenancy would be our advice, wouldn't it?
Yeah, if the access request letters fail.
So this sounds like another situation potentially for mediation then. So could you guys get involved
Potentially,
in trying to bridge that communication gap?
Usually, from the initial letters that we send. So if the landlord has been sending their own communication, it comes to us, we send out our initial letters. And, that really does highlight the importance, not only for the landlord, but for the safety of the tenant, for them to grant the access. And usually, once you've exhausted that process, it would be, like Leah said, the Section 8 route.
Right, amazing. Well, that's the end of the feedback from our landlords. So first of all, I'd like to thank all of our landlords, all of our agents for the questions and scenarios.
Yeah, thank you.
Yeah, so thanks to them, and thanks to you, Bex and Leah, again for getting all the questions right, the process, so that's great, and for answering all the different scenarios. So hopefully we've reassured landlords and agents if they have any queries about any of the evictions, debt management, serving notices and so on that we've talked about in previous episodes, that you've answered a lot of those questions. So really informative episode. So thanks, guys.
Yeah,
again.
Thank you very much.
And thanks to everyone who's watched episode 5.
Thank you.
Thank you.